everyone. My name is Niharika Salar, and I welcome you all to this webinar, which is organized by the DPIIT IPR Chair and NC Banerjee Center of IP Law here at NALSAR University of Law. My name is Niharika Salar, and I am honored to be able to talk here about philosophy and basics of IPR, the basic role in research and development. I'm very happy and I'm very thankful to Professor Anandya Sirkar, the DPIIT chair, and all the other people who are involved in the organization of this event. I am currently working here as an assistant professor of law, and I hope that we will be able to organize more of these events and hopefully also attend in person. So let's just get started with this. As I mentioned, I'm here to talk about the basics of IPR, and I'm trying to connect it with the philosophy of IPR. Now, in common language, this term property, it usually is all about resources or assets of some sort, which it can be physical, it can be physical in the sense it can be tangible, it can be materialistic, or any other asset over which somebody can exercise some kind of control which is justified to some extent. So if you look at it from a very broad point of view, from a broad perspective, intellectual property is actually taken to mean the opposite of physical or tangible property, and therefore it becomes synonymous with immaterial property. So when you're looking at the term property, right, it's kind of evolved in the society as a more recognized and enforceable claim, which is meant to claim some benefits or use of that resource. Now, these rights are of course transferable, like you see in the known concepts today, and they can be treated as property or resources in themselves, actually. So a property right is essentially this social construct which has to be differentiated from whatever the underlying resource is. And that's why intellectual property becomes even more complicated, because here you're trying to talk about aspects like patent rights or copyrights or design rights, which you can't really place your finger on, or you can't categorically point out what we are trying to protect or where the right is, or what is the subject matter over which such hue and cry is all about. And that's why when you put notions of the traditional tangible property, which you are aware of, to this new property which the world is learning to live with, of course, complications do come up. So you have these property notions which are applicable. And some of you may be aware of this, but as far as property notions are concerned, in general, they can be divided into these two categories. You can look at it from a natural rights school of thought, or you can look at it from a utilitarian school of thought. As far as natural rights is concerned, it basically finds inspiration in ideas of law, and it's basically a part of this this movement which came about in the 18th and 19th century. And as far as the perspective of this school of thought was concerned, the idea was that any individual was looked on as having some kind of natural claim to the results of his or her labor. And that kind of labor could be mental or it could be physical. So in particularly the results of any individual's intellectual labor, they are also seen as an extension of that individual's identity. And that's an extension of which the individual should ideally not be deprived of by others, especially not by organizations or by societal institutions. And in contrast to this is the utilitarian school of thought, where the idea is that it eventually declined in influence, though. That is the natural rights, and that's where you could see the growth of a utilitarian school of thought eventually. And it basically held the ground that the initial traditional rights like patent rights, they were creations by the society for the society, for the purpose of serving the larger economic interests of its members. And this more economically or more utilitarian oriented IP notion can find its roots back in Venice, back in the 15th century, and it gradually, gradually it gained a lot of traction, and it gained a lot of strength because economic concerns started increasing, and everyone thought of these economic concerns because you had side events happening like industrialization and the World War. So this philosophical debate over IP then has really shifted more into various arenas of law and even economics for that point of view. But even keeping all of that aside, the current debate about IPRs in connection with, say, newer technologies like, say, software or internet or culture, they can be broadened into general philosophical issues. And therefore, the distinction between what the natural rights school of thought says and what the utilitarian school of thought says become even more important. Now, IP notions, if you're applying in the legal and the economic perspective, of course, this general concept can be applied. It has been dominated. And there's also a certain convergence of physical property, of general notions which are actually defining property as a bundle of rights. And any extension from physical to intellectual property, that can be strongly limited by a lot of obvious differences, right? So you can see some of these obvious differences on your screens. And one such difference is essentially the idea of possession. You can possess physical assets, but it's very difficult to ascertain possession over something like intellectual property. So, for example, the rights of an individual to say a certain piece of property that can be seen, that can be that can derive in principle from the basic characteristics of what the individual had at that point of time. That was a physical possession of that whatever physical property was there. But the possibility of extending this concept to something like intellectual property, how can you show that who was in possession of the idea first? That becomes very different, and sometimes it's also fundamentally different from possession of what physical property would have led to.
These ideas to intellectual property that could ideally be limited by the fact that you can't really showcase possession of an idea, right? Or you have these certain more issues like differences with respect to dispossession impossibility. The fact that I had a physical and a tangible property, and by way of licensing or by way of selling it out, I now extend or I transfer the ownership to somebody else. But that kind of dispossessing something can't be applied that easily to intellectual property, right? Because this act of stealing, it does not really dispossess the information owner or the idea owner of whatever information or idea that person had. So this transfer in the possession of, say, knowledge, it's more or less irreversible, right? Like it was for, say, a tangible property. So how would then principles of physical property apply to intellectual property? And in contrast to then physical things, of course, information can also be shared at will. It can be done cheaply. I wanted to share my idea. I wanted to share my recipe. That's something which I talk about extensively here at NALSAR, which is IP's negative spaces. where IP executive spaces essentially, that area of IP industries which is thriving, despite the fact that there is less IP protection, which is essentially questioning the very existence of copyright protection and therefore IP protection. I'm happy to have a chat in case you're interested to know about that. But coming back to the point, if I wanted to share my recipe, I would not, I could probably easily do so because it's just an idea. So in that sense, any given piece of open information will not be scarce or will not be less. So scarcity really would not warrant defining that property right. But if an individual can also choose to keep information secret, perfectly contained, at no direct cost whatsoever, um, and then therefore can enforce scarcity. So there is no guarantee that others will also remain excluded from that kind of information sharing or from that kind of tangible property sharing. And therefore, these are some issues or some problems which you can think of when you're trying to put these philosophical reasons from tangible property to IP. So you have these inherent differences between these objects, between the physical object, between intellectual objects. So if you're looking at any given point of time, these fundamental differences in extending, um, the question will be that what theoretical or even philosophical justifications of specific IPRs have been voiced. Now, generally, these justifications can be, say, can be of these two kinds. And you can see them on your screens right now. They're essentially either deontological justifications or they are consequentialist justifications. To summarize it, deontological justifications are basically based on moral rights and rules, which are largely or which are basically exogenous to the economic system. That is that they're natural rights. Whereas on the other hand, consequentialist justifications are based on the more economic consequences of legally recognizing your IP. So the idea of labor theory, the idea of the Lockean natural rights could be put within the broader umbrella of deontological justifications. And therefore, you can also see that that aspects of identity, the personality theory, or some of you may have read Hegel's work on this, that could come within the broader umbrella of deontological justifications. And consequentialist justifications, on the other hand, they are more utilitarian in nature. They refer to fulfilling this preference which a consumer would want to put forth as far as, say, meeting proper ends of human life is concerned. And this kind of focus on the nature of incentives which IPR can afford becomes very quintessential of this entire justification. So in this sense, then incentives can take the form of, say, a reward or say a monopoly right or just a right in general, some kind of prize. So this monopoly right reward is what stems out from this kind of a justification. And the main idea of this is that IPRs in general should be tailored to a sense that it should deprive others of some rights and it should give more rights to the IPR owner. And that's usually done through limited monopoly because, of course, then you have limited terms of protection, right? Patents give you a certain number of years, copyrights give you a certain number of years. Why copyright essentially developed into the death of author plus a certain number of years can be discussion of another class altogether, and I would love to have a chat with you if any of you is interested. Coming back to these justifications, So when you're looking at R&D, and I want you to think about this, I want you to think about what kind of justifications would be more applicable, right? Because consequentialist justifications are essentially the utilitarian ones. And you will see that these justifications, they are they're dominant in the contemporary legal and economic philosophy of IPRs. And I do want you to note that this does not really imply that there are no objections at all to these justifications, but you see that the applications of these justifications are happening, or they more easily fit within the facts of what we are aware of today. Now, coming to applying these concepts in research and development. Now, given the fact that the context of this webinar is IP issues in post-COVID world, I thought that sticking to research and development in medicines would make more sense. Now, of course, COVID-19 has caused all kinds of disruptions. Probably we will do all of this in person the next time, and it would be a much better interaction. Like at this point of time, I'm not even able to see how many people are there, or even their videos for that matter. But my point being that COVID-19 has, of course, caused a lot of inconvenience, to say the least. It has spread across a number of countries. It's kind of changed our world, forced us to go from offline to online, and of course has also raised an alarm um, for the dire need of a vaccine, right? Of course, we have kind of crossed that stage, and you may have seen these various developments like university professors coming together, signing a letter so that we don't require patents on the vaccine, or India or Brazil moving so that certain kind of restrictions are placed. But amidst all of these critical situations, IP is necessary, and you can't really deny it, because it's necessary for every mind to be aware of that same, right? It is already known that protection of IP is a key feature which fosters innovation, and which kinds of act as this motivating factor for businesses and for researchers to invest in research and development, and therefore also get an ROI, or the return on investment on their investments. And of course, when I'm talking about investments, I'm not just referring to the economic aspects of it. I'm also, I mean, though that would cover a major part of the IP, but it's also interesting to think about other investments like labor and other resources investments. So just to give you an example of the divide between what's happening between the money spent on pharmaceutical R&D for diseases which might be prevalent in, say, the developing world and the developed world. Some of you may be aware that actually less than 5% of the money spent worldwide, like globally, on pharmaceutical R&D is actually for diseases which are affecting the developing countries. Whatever pharmaceutical research you have by the private sector, that is essentially driven by commercial considerations. And if at all, that effective demand in terms of the population, in terms of market size, is not there, or is small, then even for the most common diseases like TB and malaria, um, there is just no motivation to invest in that kind of R&D. So like Professor Vivekanandan was correctly saying, like, you can put time within AD and VC in terms of IP aspects. You can put, or you can divide the time frame between pre-trips and post-trips. So post-trips, there have been some changes which I'll quickly circle back to in a minute. But the resources towards R&D towards diseases like TB and malaria, which was effectively predominant in countries in the African continent. That was, of course, pre-drips. Things have kind of gotten for the better post-drips, but I'm here to try to explain you that what philosophical justifications could be applied there. So, regardless of all the IP regime which is prevailing in these developing countries, the harsh reality is that there is very little commercial incentive for the private sector to undertake these research activities, which could be specifically relevant to the diseases which are majorly affecting poor people who are living in low-income countries. So that's the reason why you may say that there's actually little such work which is done by the private sector. If you look at the total pharmaceutical R&D, it has probably doubled in the last decade. But exactly what proportion of that is directed or is meant to diseases which are affecting mainly developing countries, that is still very hard to determine. According to some study, I think about some out of some 1,393 drugs which were approved in the late 1980s, there were only 13 which were specifically designated for tropical diseases. So where diseases are common to both developed and the developing countries, there, of course, the picture is a little different. And there is a significant private sector R&D on these kinds of diseases. But even then, you see contrast. Like, for example, you have significant R&D on, say, disease like HIV/AIDS. And this is very different from whatever work you have seen in, say, TB and malaria, which was virtually none up to a certain point of time. And even when you're looking at the development of, say, HIV/AIDS, some of you may be aware that the beta kind which it attacks, the drugs which are in the market right now, it serves only to a certain kind of a certain beta type A and C, which is available or which is more predominant in the developed world, whereas beta type B is the one which is more prevalent in the developing world. So the idea is that if you're looking at from a consequentialist justification, you may find some relevance. You may be able to draw some parallels with whatever evidence we have so far. And then the question becomes that what role does IP protection play in stimulating R&D on diseases which are prevalent in, say, developing countries? And it would only be fair to suggest that whatever studies have been done so far, whatever evidences have been collected so far, though there is one very interesting paper, and I'm happy to share with you if any of you is interested, which suggests that even the studies which are carried out by WIPO, the WTO, the research methodology which they entail is highly problematic in the sense that they are only referring to doctrinal studies, and they do not go on ground and conduct empirical studies to know the actual result. So I say this and I add this like a footnote to whatever I'm about to suggest, or rather not conclude, but yes, suggest on whatever evidences we have so far. Like I said, I'm happy to share the paper in case any of you is interested. So whatever studies have been done so far, there is very weak evidence which is trying to draw parallels between indicators of research activity and between IP. All of the evidence, it suggests that it actually hardly plays any role at all, except for those diseases where there is a large market in the developed world. For example, diabetes or heart diseases, more prevalent. And again, these come from people who have that luxury, like, because all of these diseases are more prevalent in obese people, and obesity, of course, may be more prevalent in the developed world. So that is why a lot of people believe that presence or the absence of IP protection in the developing countries will probably be secondary best importance to generating these kinds of incentives for research. And therefore, you have these inequalities in research, which is particularly on vaccines also. And they may require, tackling characteristics of diseases which are specific to developing countries, where the solution which you are putting forth for the developed world may not be equally applicable to the developing world. So, for example, I gave you the example of AIDS, type A and C, and and the subtype B, which is a more genetic profile, right? Which is available, or rather seen in the majority of HIV cases. And therefore, the vaccine research for HIV is also particularly challenging because of the way the virus evades in the body's natural immune responses. That's one of the major reasons why we are having difficulty, or rather, even COVID-19 vaccine falls within this huge gray area because of the number of mutants which are coming every day. So look at it from the private sector point of view. For the private sector, vaccine research is a very high risk and a very low return investment. And it's particularly in relation to those diseases or those disease types which are prevalent in developing countries. So the market which is available out there, it, it, it tends to undervalue the social returns from these vaccines. And it tends to prefer more the economic returns from these vaccines. So say even in the case of malaria, the market demand is dominated by a lot of travelers from developed countries. And therefore, when you're putting out vaccines out there, it would be of greater relevance to the developing world, which may not necessarily be the cause of that disease. Even if you're looking at, say, TB, and the course which is available for TB is very long, is very exhausting, if I may say. I mean, I can say because my younger sister developed TB very recently. Thankfully, she is fully cured now. But there are an estimated 8 billion people in developing countries which have this disease. And there is no new class of anti-TB drug, right, that has been developed for over 30 years. Whatever current treatments we have, that requires drug courses of, of 6 months or even more than that. So a drug which then produced the same effect in 2 months could have a more dramatic impact in helping to control this disease globally. And then of course you have these problems where people are not motivated to continue their course. You have these advertisements where Amitabh Bachchan constantly tells you that please complete the course, right? So these are some challenges which are out there, and and you can see the inequalities. Now, as far as arguing or putting philosophical justifications are concerned, developing countries' diseases. And evidence of this again is minimal because most of the relevant countries have only just introduced TRIPS compliant laws, or some are even yet to do so. And therefore, there is no reason to see that why firms or big organizations with research capabilities in developing countries, they should respond to the global IP and market incentives, especially differently from those in developed countries. There's also some studies to suggest the reason behind this behavior. Um, there is some suggestion here. And the reality is that private companies will only devote these resources to, those areas where there is establish differential pricing. And establishing differential pricing would reduce the marginal returns to reward R&D in developing countries. And therefore, that would actually take a step ahead in undermining any incentives for any kind of additional research which somebody may be interested in. IP protection may or may not make a significant contribution to increasing R&D expenditure, at least as far as the private sector is concerned. And this again has to do a lot with respect to consequentialist justifications, which in turn can find some roots from the utilitarian, from the more economic perspective. And the only feasible way to do so, or at least do this, is by or at least some people suggest, that the quantity of international aid resources which are devoted to such R&D should be increased. These could be some possible solutions as far as motivating R&D is concerned. Even more global organizations have recommended that at least an additional 3 billion US dollars need to be annually spent on R&D through a more studied channel, like a more global health research fund. And how increased publicly funding research should be directed, that also requires a lot of careful consideration, right? It should not just be an act or like a form of subsidy to whatever pharmaceutical industry is there at this point of time. And the opportunities which should be taken to build up the capacity of developing countries themselves so that they can undertake this R&D on treatments should be there. Like for example, some of you may be aware that this company called General Electric established its second largest R&D center here in India, and it employed about 1,000 employees with full PhDs, and 27 other global firms have also set up their R&D centers here in India. So research could be conducted with this active participation of selected research institutions, and of course also companies in developing countries which are taking advantage of not just the economic benefits, but of course the human resources which are also available rather in abundance in these countries, and lower R&D costs. One thing to also keep in mind is that the institutional structure for a lot of these funding also needs careful thought. It may be more promising as far as at least this context is concerned. Some of you may also be aware of arrangements like the public-private partnerships in developing countries. They're also taking advantage of the concentration of these research resources in public sector institutions, but they're also taking or they're also providing opportunities to build research capacities in the private sector. So this arrangement of intellectual property, which is arising from this kind of research, this then needs to be such that that access by the poor is ensured as much as possible. So, of course, with respect to R&D, more wings of IP law would be the patent law and how you go about globalizing it. You have limitations to it, like all other laws, like limited limited right, limited period of right. Then you have exceptions like compulsory licensing, which countries like India to some extent have taken a benefit of, but I feel, in my personal opinion, it's still a little too early to decide, how much of a progress countries like us can make out of it. And then coming down to the fundamental question that as much as we like to believe that the utilitarian, the utilitarian school of thought should be applicable to research and development, just like how it's applied to other wings of IP law, like say copyright law, um, where the idea is to is to create for the benefit of society and you give limited rights. The reality is that it's very hard to draw a similar parallel with research and development, at least, and I'm saying this with a caveat, I'm restricting myself only to the pharma industry. I'm not talking about academic R&D. As much as we would like to believe, the utilitarian point of view is very hard to see here. We still see economic benefits. We still see motivations with respect to the size of the market, with respect to the return of investment, rather than the social welfare, which essentially was meant to start. I would like to end here now, and the reason I'm ending early is because I want to have share. I have time.
Thank you so much, ma'am. Now,
I have any questions.
yes, ma'am. I'm just going to check if there's any questions.
I will also put my mail here in case anyone would like to get in touch with me.
So, I would like to tell the attendees that that the session is now open for questions. So please drop in your questions either in the chat box or in the Q&A section. So, Ms. Solar, we have a question from Apurva Pragya. She asks, how do you think the idea of property in intellectual property is changing in digital world with the gradual shift from intellectual goods to services, like the subscription streaming services, where one doesn't really own the product one paid for?
Right. So this actually adds to how I'm, trying to portray the difficulties in applying the principles of tangible property to IP. And let me explain this to you with an example, like you mentioned, streaming services, right? You may be aware of Spotify, the music app, right? How Spotify essentially works is that they have created this business model where where on a subscription basis, you can, of course, listen to music. And if you have paid that certain subscription fee, you can also download that music. You can download those tracks on your device and then listen to it, as per your convenience, as per your leisure. This changes a lot of things because now Spotify has taken a mechanical license from all of those publishing houses and from all of those copyright societies, which may be responsible for collecting royalties. So the idea that how a tangible property has changed to, say, a song has completely changed, right? Things like sharing has become much more convenient. Things like I mentioned also in my slides, the fact that now it's no more scarce, it's there. So IP in these contexts would not be working to create a false scarcity, but would actually be creating to make it more and more accessible. So as far as digital content is concerned, or these days the meta world, right? You may be aware that there's actually active litigation, not active litigation. There's actually a suit which was filed by this high-end luxury brand called Hermes, because somebody created NFT of their Hermes bags. So how it operates in the digital world, is of course a very gray area. And I remember reading a study which said that a possible solution could only be creating a set of rules which would be applicable in that world. Because like I mentioned, issues like these sharing and how you would look at the tangible property, what kind of rights you would put forth would change tremendously. So I'm not sure how much I have answered your question, but I think I'll answer like every lawyer says, it depends. But I'm happy to have a longer chat with you in case you're interested.
Thank you so much for answering that, ma'am. We have another question from Bhavya Upadhyay, who asks, can you please elaborate upon your statement that compulsory licensing might not prove being very fruitful for a country like India?
So as if when I say that, I mean that in the post-TRIPS world, we have not had a chance to explore compulsory licensing a lot. We have only done it. I mean, there was only active litigation for, say, one drug which was able to satisfy the needs of compulsory license. And like I say that even like a limitation, do note that compulsory licensing acts like a limitation for a lot of companies, right, who want to put in incentives for R&D. That may still not work because the state is essentially putting a bar on you, is forcing you to provide your medicines to a certain group of people for, say, limited for say a limited fee, or um, ideally not a fee which you as the investor would have wanted to. So it's an example of how the social welfare theory works, of course, in research and development. But that's also the reason why I'm saying that it's still too early to suggest that it's acting as a good motivation for companies um, to invest in their research and development here. Even other Southeast Asian countries like, say, Thailand, I believe only one drug has been able to surpass that. These are all countries which have only recently, um, you know, uh, put up their laws, and that's the reason why I said it's a little early to suggest that it's a solution uh, for 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 whatever it means.
I hope that answers the question. Now we have a general insight from Sujata, and she wants you to comment on this. So she says that as someone who's worked as a researcher in universities as well as in pharma industries as a consultant, she feels that a combined effort and focus from universities and pharma can help come up with a better affordable medicine for diseases such as TB and malaria. I think this is an extension of the story that you personally shared. So she says, and also government incentivizing such research can definitely push these less researched diseases to come into focus. So she wants to hear your comment on this.
Yeah, I think, and I remember saying this somewhere else too, that we as a country have huge potential for research and development. But up until now, we were struggling to channelize it. I mean, of course, I don't want to make any political statements, but in my opinion, probably the current government has been able to in the past few years. And I mean, it has played a huge role in vaccine diplomacy, stating that we were one of the very few countries who were able to come up, or who were able to answer the pandemic with an actual working vaccine. So of course we need some incentives, and this kind of vaccine, say, it was only possible because it was it was like a partnership between Serum and another academic institution. So while I completely agree with you that these combined efforts between universities and pharmas, they can definitely help come up with better and affordable medicines, my question still remains that if you're looking at from a more philosophical point of view, we still don't look at social welfare, we may still be looking at only economic benefits. To that extent, government intervention by way of, say, policy, or by way of, say, yellow papers could still come in handy, but I will reserve my comments on that. I will still see it's limited. Yes, particularly because the pharma is very good at generics, and that is what helped us in coming up with solutions for other countries' problems as well. Right. I completely agree with you, Sujata.
Thank you so much for your comments on that. I do not see any questions or comments any further. I think you can just wait for a couple of minutes before we move on to your
Sure.
concluding remarks.
Sure, I'll be here. So even the reason why I was not able to join from the other gathering was because I was busy listening to Professor Vivekanand's class lecture. So yeah. I have put in my email. I'm also available on LinkedIn by the same name, Niharika Silar. Probably you will not find any other Niharika Silar, so it would be easy. So
Ma'am,
feel
I
free to
think
drop.
you have sent the mail to the host, so we will just send it back to everyone on the chat.
Oh, I sent it to the host. Okay, okay. I'll just put it to everyone then.
So I do not see any more questions. Ma'am, would you like to make any concluding remarks?
Yeah, as somebody who is working at NALSAR, I'm extremely happy to see these initiatives being taken by the IPR chair, and many thanks to Professor uh, Sirkar for having us on board, and for letting us know that more good things are about to happen here at NALSA with respect to IP, and we're gearing up to host more such events, hopefully in person when situation becomes better. And I would invite you all to visit NALSAR whenever you have the time, whenever you're here in the city. It would be great. We would love to host you. And yes, that's all from my end. Uh, Hoping to have more such webinars from the IP chair. Right.
We're looking forward for such more sessions as well, ma'am. Thank you so much for connecting with us today. Oh,
Thank you. Thank you for the invite. I'll be here for the next session.
thank you, ma'am.